Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Reckless Homicide Lawyer, Chicago, Illinois. Facing a reckless homicide charge in Chicago, Illinois can be overwhelming. Often arising from fatal car accidents, reckless homicide is a manslaughter offense that essentially serves as Illinois' version of vehicular homicide, and prosecutors treat it seriously. A conviction can lead to significant prison time, large fines, and a permanent criminal record that can impact your future for years to come. If you've been charged with reckless homicide in the Chicago area, it's critical to act quickly and secure experienced legal representation. At Combs Waterkotte, our Chicago criminal defense attorneys bring decades of experience to every case, working to understand the full context of the incident and build a defense aimed at reducing or dismissing the charges against you. Call 3125-00-HELP today to start protecting your rights and your future. Reckless Homicide Lawyers in Chicago, Illinois, serving all of Cook County. A reckless homicide charge in Chicago, Illinois can quickly turn your life upside down. With Cook County prosecutors aggressively pursuing these cases, you need a defense team that understands both the legal complexities and the high stakes involved. Trying to handle a charge of this magnitude on your own can put your freedom and future at serious risk. At Combs Waterkotte, we bring over 8 decades of combined criminal defense experience to every reckless homicide case we handle in Chicago and throughout Cook County. We understand that these charges often arise from chaotic, fast-moving situations, and we take the time to fully investigate every detail. Our attorneys dig into police reports, accident reconstructions, and witness statements to identify weaknesses in the prosecution's case. When you work with our firm, you receive a defense strategy tailored specifically to your circumstances. We focus on challenging the evidence, questioning assumptions about recklessness, and negotiating with prosecutors to reduce or dismiss the charges whenever possible. If your case proceeds to trial, you can count on us to be fully prepared to fight for a not guilty verdict. Your future is too important to leave to chance. If you or a loved one is facing a reckless homicide charge in Chicago or anywhere in Cook County, contact Combs Waterkotte today. Call 3125-00-HELP or reach out to us online to schedule a free confidential consultation and start building your defense. What is reckless homicide in Chicago, Illinois? While there is no statute actually called vehicular homicide under Illinois law, a reckless homicide charge is basically the state's version of one in everything but name. A homicide offense grouped under the same statute as involuntary manslaughter. Reckless homicide in Illinois is defined as causing the death of someone else while driving recklessly in such a way that is likely to cause death or great bodily harm. With that definition in mind, it's important to understand what Illinois considers to be reckless driving. 625 ILCS 5/11-503 defines reckless driving as driving any vehicle with a willful disregard for the safety of people or property. Knowingly driving a vehicle and using an incline to cause it to become airborne. Reckless homicide essentially arises from situations in which someone drives wildly or aggressively and, in doing so, kills another person. The penalties for doing so vary based on the circumstances of the accident, like who was killed and where. Reckless homicide sentence in Chicago, Illinois. Reckless homicide is always charged as a felony in Chicago and Cook County, Illinois. The standard charge is a Class 3 felony, a conviction for which results in anywhere from 2 to 10 years in prison. There are some instances, though, where reckless homicide may be enhanced. In Cook County and Chicago, reckless homicide may be charged as a Class 2 felony under certain circumstances. A Class 2 felony typically results in a prison sentence between 3 to 14 years. But the Illinois Reckless Homicide Statute defines additional penalties for more severe cases. If a reckless homicide death occurs in a school zone or construction zone, 3 to 14 years in prison. If 2 or more people are killed in a school zone or construction zone, 6 to 28 years in prison. Reckless homicide is also charged as a Class 2 felony when a death occurs as a violation of Scott's Law, or the move-over law, which requires drivers to slow down or change lanes when a stationary police, fire, EMS, or tow vehicle is present. Offenses that violate Scott's Law result in a 3 to 14-year prison sentence, or a 6 to 28-year prison sentence if 2 or more people are killed. Illinois law also covers instances of reckless homicide of an unborn child. The statute, 720 ILCS 5/9-3.2, defines the offense as a Class 3 felony, a conviction for which may result in up to 10 years in prison. What to do when charged with reckless homicide in Chicago, Illinois? A reckless homicide in Chicago or Cook County should be taken very seriously. When you're arrested or charged with reckless homicide, it's important to take the right steps to defend your legal rights and aid in your own criminal defense. The expert defense lawyers at Combs Waterkotte recommend doing the following if you're charged with reckless homicide in Chicago. Invoke your right to remain silent under Illinois law. After an arrest for reckless homicide in Chicago, do not provide statements to police without counsel present. Although Illinois law focuses on whether your conduct was reckless, your own words can be used to establish that mental state. Politely decline questioning and request an attorney. Prosecutors often rely on statements to prove recklessness, so protecting your rights early can significantly impact how your case develops. Call a defense attorney familiar with Illinois' reckless homicide laws. Your defense attorney must understand how Illinois courts interpret recklessness in vehicular deaths. This includes analyzing whether your actions created a substantial and unjustifiable risk. An experienced Chicago defense lawyer can immediately begin reviewing police reports, crash reconstructions, and witness statements to challenge whether your conduct actually meets the statutory definition required for a criminal conviction. Be aware of felony classifications. Reckless homicide is generally a Class 3 felony in Illinois law, carrying potential prison time and long-term consequences. However, aggravating factors like driving in a school zone, construction zone, or causing multiple deaths can elevate the charge to a Class 2 felony. These enhancements significantly increase sentencing ranges, making it vital to understand exactly what level of offense you are facing early in the case. Preserve evidence relevant to your defense. Because reckless homicide cases in Chicago often hinge on accident reconstruction, preserving evidence is critical. This may include dash cam footage, vehicle data, roadway conditions, or witness accounts. Illinois prosecutors must prove both reckless conduct and that your actions caused the death. If alternative causes exist, such as another driver's behavior or environmental factors, your defense attorney can use that evidence to challenge causation under Illinois criminal law. Avoid actions that could support the prosecution's charge. Illinois law allows juries to infer recklessness in certain scenarios, such as driving significantly above the speed limit or violating specific traffic statutes. Statements, social media posts, or even behavior after the incident could be used to reinforce that inference. Limiting your communications and following legal advice helps prevent the prosecution from building a stronger narrative that your actions met the statutory threshold for reckless conduct. Prepare for how Chicago courts handle reckless homicide cases. In Cook County, reckless homicide cases are often prosecuted aggressively. Courts will closely examine police reports, toxicology results, and expert testimony. Pretrial motions may challenge whether evidence supports the statutory elements of the charge against you. Understanding local court practices, including how judges handle bond conditions or evidentiary issues, can help you and your attorney better prepare for each stage of the process. Act quickly to build your defense. Time is especially important in Chicago reckless homicide cases because evidence can disappear and witness memories can fade. Early legal intervention allows your attorney to challenge the state's interpretation of recklessness and preserve favorable evidence. Given the serious felony exposure of a reckless homicide charge, taking action sooner rather than later can make a huge difference in negotiating charges, pursuing a dismissal, or preparing for trial. Criminal defense strategies for Chicago, Illinois reckless homicide charges. In a Chicago reckless homicide case, a good criminal defense can mean the difference between freedom and years in prison. At Combs Waterkotte, we've handled vehicular manslaughter cases in Chicago before, and these are some of the criminal defense strategies we've found to be most effective in getting charges reduced or dropped altogether. Challenging the state's claim of recklessness. A central defense in any reckless homicide case is disputing whether your conduct meets Illinois' legal definition of reckless. The state must prove a conscious disregard of a substantial risk, not just negligence or a mistake. Your attorney may argue that your actions were reasonable under the circumstances, lacked awareness of risk, or were momentary errors that do not rise to criminal recklessness. Arguing lack of intent. Reckless homicide requires proof that the defendant acted with disregard for life or property. A defense may focus on showing the incident was a true accident without any conscious disregard for safety. For example, a sudden mechanical failure, unexpected road hazards, or medical emergencies may negate the required mental state and prove a lack of intent. Demonstrating the absence of recklessness can lead to reduced charges or even dismissal under Illinois law. Disputing cause of death. Even if reckless behavior is alleged, the prosecution must still prove that your actions directly caused the victim's death. A strong defense may argue that intervening factors, like another driver's conduct, poor road conditions, or delayed medical care, were the true cause of death. Illinois law requires a clear connection between your action and the fatality, and breaking that link can significantly weaken the prosecution's case. Challenging evidence under the Fourth Amendment. If Cook County law enforcement obtained evidence through an unlawful search or seizure, your attorney may file a motion to suppress that evidence. This could include improper vehicle searches, unlawful blood draws, or warrantless data collection. If key evidence is excluded due to constitutional violations, the prosecution may be left without enough proof to sustain a reckless homicide charge in Chicago courts. Suppressing statements under the Fifth Amendment. Statements made during Chicago police questioning are usually critical in proving reckless homicide. If officers failed to provide proper Miranda warnings or coerced a confession, those statements may be inadmissible. A defense strategy may focus on suppressing self-incriminating statements obtained in violation of your Fifth Amendment rights, limiting the prosecution's ability to establish your mental state. Raising necessity or emergency circumstances. In some cases, a defendant's actions may be justified by necessity, meaning they acted to prevent greater harm. For example, swerving or speeding to avoid an imminent collision could be framed as a reasonable emergency response rather than reckless conduct. While these factors vary from case to case, this defense can be effective when the circumstances show that your actions were driven by urgency rather than a disregard for safety. Using expert testimony to challenge the prosecution. Accident reconstruction experts, medical professionals, and forensic analysts can play a crucial role in Chicago, Illinois reckless homicide defenses. These experts may dispute how the crash occurred, whether your conduct was truly reckless, or whether your actions really caused the death. In Chicago courts, expert testimony is often key to creating reasonable doubt and countering the state's technical evidence and conclusions. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.